Hi. Today, we're going to talk about common mistakes notary makes. My name is Phyllis Trailer, and I want to welcome you to my YouTube channel. And thank you so much for joining me today. Now again, today we're talking about common mistakes that notaries make. And one of those are failing to verify the signer's identity properly. So again, in Texas, notary publics must verify the identity of a signer before notarizing a document. The Texas Secretary of State specifies that acceptable forms of identification must be government issued, contain a photograph and signature of the individual, and must be current, meaning not expired. Here are the commonly accepted forms of identification. In Texas, we can use a Texas driver's license or a Texas identification card issued by the Texas Department of Public Safety. You can also use the card for carrying a concealed handgun. It looks just like a driver's license, has all the information basically that the driver's license has, with the exception of the driver's license number and a few other things, but that can also be used. We can use a U.S. passport, a U.S. Military ID card, because the U.S. military ID card, we can use it as long as it has a photograph and a signature. We can use driver's license or identification cards from another state. And we can use foreign passports, but only for real estate documents. That's the only time that we can use foreign passports. It's only for real estate document. Now, these forms of ID must be issued by a governmental entity. Social security cards, birth certificates, and other non-photo IDs do not qualify as acceptable identification. If the signer does not have valid identification, then their identity may be established through a credible witness who is willing to swear to the identity of the individual. Next, we have incorrectly completing notarial certificates. In Texas, a notary public has specific responsibility related to completing the notarial certificate when notarizing a signature. The notary must ensure that the certificate is filled out accurately and in accordance with notary laws. Also, we are 100% responsible for completing that notarial certificate correctly. That notarial certificate is ours. Nobody else is responsible for completing that notarial certificate but the notary. So you can't leave out any details or anything on the notarial certificate. You have to fill it out completely, and you have to sign it and date it. So here we have a sample notarial certificate. This is just a simple acknowledgement. But you have to make sure that the venue area is completed with the state and the correct county. The county is where the notary is at the time of the notarization. That's so important. You're going to include the county that you are at when this notarization is taking place. The date of the notarization, the signer's information, and also you, the notary, are going to sign it and you're going to stamp. This is important. This is your responsibility. The notarial certificate is totally 100% your responsibility. The primary responsibility of a Texas notary for the notarial certificate is 1, ensure completeness and accuracy. The notarial certificate must be fully completed with the notary's name, the date of the notarization, and the type of notarial act performed, such as the acknowledgement or jurat. The notary should ensure that all information in the certificate corresponds with the information provided by the signer, including the name of the signer and the date the document was signed. include the notary signature. The notary must sign the notarial certificate exactly as their name appears on their notary commission. Affix the notary seal. The notary must affix their official seal or stamp on the notarial certificate. The seal must include the notary's commission name, the words Notary Public, State of Texas, and the commission expiration date. Certified personal appearance. The notary must confirm that the signer personally appeared before them at the time of the notarization. The notary must include in the certificate to indicate this, as well as the form of identification used to verify the signer's identity if applicable. If you have found any of this information in this video helpful so far, please give it a thumbs up and don't forget to subscribe to the channel for more notary tips and guides. In Texas, notary publics are required to maintain a record book journal of their notarial acts. The information to record. The notary must record the following for each notarization: the date of the notarization, the type of document being notarized, the name of the signer, a description of the identification used to verify the signer's identity, excluding identification numbers like those on passports or government-issued IDs, so we can't include any of the identification numbers in the notary journal from the passports or any other government-issued IDs. Whether the notary knew the signer personally or relied on credible witness. The fee charged, if any. Prohibited information. The journal cannot contain identification numbers such as those from government-issued IDs like driver's license or passports, nor any biometric data such as fingerprint. So we don't put thumbprints in our journals in Texas. That is against the law. I repeat, we do not put thumbprints in our journals in Texas. That is against the law. Retention periods. Notaries must keep their record books, journals, for the duration of the notary commission or for 3 years following the date of the last notarization, whichever is longer. Format. The record book can be either physical, a bound journal, or electronic, provided that electronic records are properly backed up and can be printed if necessary. A Texas notary cannot give legal advice. This includes preparing, drafting, selecting, or providing advice concerning legal documents. Notaries in Texas must refrain from any act that constitutes the unauthorized practice of law, as this can result in penalties, including the suspension or revocation of their notary commission, civil liability, or even criminal prosecution. The improper use of a notary seal in Texas is strictly regulated, and violations can lead to significant consequences. Here are key points regarding the improper use of a notary seal. Correct name on the seal. A notary must only use the name under which they were commissioned. Signing or using a seal with any other name is prohibited. Exclusive control. The notary must maintain exclusive control of their seal at all times to prevent misuse. Using an expired or invalid seal. It is unlawful to use a notary seal or digital certificate that has expired or is no longer valid. For online notaries, failure to report changes to the digital certificate or electronic seal can also lead to disciplinary actions. Disciplinary actions. Improper use of a notary seal, such as using a seal that does not comply with statutory requirements, or notarizing documents without properly affixing the seal, can result in the revocation or suspension of the notary commission. Thus, misuse of the notary seal is considered a serious offense and can lead to penalties under Texas law. Now, this is not saying you have to be perfect. Every now and then, you're going to make a mistake. What this is talking about is doing something intentionally improperly using your notary seal, intentionally not dampen a notarial certificate the way it should be. If you didn't do these things intentionally, then you open yourself up to repercussions. Not administering the oath or affirmation properly. In Texas, when administering an oath or affirmation, a notary public should follow these guidelines. Number one is personal appearance. The person taking the oath or affirmation must be physically present before the notary. Verbal affirmation. The notary must ask the person to raise their right hand if possible and verbally affirm or swear that the statements or information provided are true. Now, they don't have to raise their right hand. If I'm giving somebody an oath, administering an oath, I ask them to raise their right hand while I administer the oath. The specific wording used can vary, but it typically follows one of these formats. For an oath, do you solemnly swear that the statements in this document are true, so help you God? For an affirmation, do you solemnly affirm that the statements in this document are true under penalty of perjury? No physical signing requirements for oaths. Administering an oath is a verbal act, so the signer is not necessarily required to sign a document during the process unless the oath is part of a written affidavit or deposition. So there will be times when you might be called to administer an oath to somebody online. They don't require a document to sign. They just need to be administered an oath because they're probably going to be given a testimony or a deposition. So they need to be placed under oath. So that's something that a notary can do. And that doesn't have to be recorded in your journal, and there's nothing to sign. It's just the act that you administer. Notary must ensure that the individual understands the significance of the oath or affirmation and that they are swearing or affirming truthfully under penalty of perjury. Not asking about the document's content. Texas notaries are not required to read the document before notarizing the signer's signature. A notary's responsibility is to verify the identity of the signer, witness the signature, and ensure the document is signed willingly. The notary should confirm that the document is complete. So Texas notaries are not required to read the document before notarizing the signer's signature. A notary's responsibility is to verify the identity of the signer, witness the signature, and ensure that the document is signed willingly. The notary should confirm the document is complete. There's no blank spaces that could be filled in after notarization. The signer appears willingly and competent to sign. The notarial certificate is completed with the correct information, and the notary's role is not to provide legal advice or interpret documents' content. Now, again, you got to make sure that all the blank spaces are completed. There's no blank spaces. If there are, you're going to have them draw a line through that blank space or insert NA because you don't want them to be able to go back after you notarize their signature and add any information to the document. Now, if the document is some type of government form, on some of these government forms, that's why you really have to pay attention to what you're doing. because on some of these government forms, it will say, leave this space blank or this, or don't add any information to a particular space. In that case, you're not going to do anything with that because you got your instructions for that particular document. Improper handling of signer's competence. So a Texas notary public has a responsibility to ensure the signer is competent in signing the document willingly and without coercion. While the notary is not required to perform detailed assessment of the signer's mental state, they must use reasonable judgment to ensure that the signer appears to understand the document they are signing and is not being pressured. Key responsibilities regarding assessing the signer's competence include willingness to sign. The notary must confirm that the signer is signing the document voluntarily. If the notary suspects the signer is under duress or undue influence, they should refuse to perform the notarization. Basic awareness. The notary should verify that the signer appears to be aware of the nature of the transaction and the significance of the document. If the notary believes the signer lacks the mental capacity to understand what they are doing, the notary should decline to notarize the signature. Right to refuse. A notary may refuse to perform a notarization if they have reasonable grounds to believe the signer does not have the competence to understand the document or is being coerced into signing. In cases of doubt, the notary has the discretion to refuse to notarize and can suggest that the signer seek legal or medical assistance if necessary. So this is going to happen. The more you do this, the more you're going to come across different type of situations. I had a situation where a lady, she contacted me to come out to a hospital to notarize her mother-in-law's signature on a power of attorney. So her mother-in-law was the hospital patient. So when I got to the hospital to do this notarization for a power of attorney, I spoke to the mother-in-law. I introduced myself. We talked for a little while. And then that particular power of attorney required 2 witnesses. So the daughter-in-law left the room to go get 2 witnesses, to go try to find 2 witnesses. So while she was gone, the mother-in-law and I continued to talk. And so while we were talking, she asked me how were we related. And I told her we were not related. And she said that she didn't understand what was going on. So the more I talked to her, the more I realized she really did not understand what was going on. And she kept asking me too. She asked me several times, how were we related? And I kept telling her we were not related, and she kept saying she didn't understand. So when the daughter-in-law returned with the 2 witnesses, I told her, I said, I'm not going to be able to notarize your mother-in-law's signature because she doesn't understand what's going on. I mean, she thinks we're related. She keeps asking me, how are we related? I said, knowing that, I said, I can't notarize her signature. And the daughter-in-law asked me, what could she do? And I told her, I said, you're just going to have to contact an attorney because at this time, I cannot help you. Annotated that information in my journal, packed up my stuff, and I left. Another mistake notaries make is they ignore state-specific laws. This is a big one, guys. You can't do that. Just because somebody can do something in one state doesn't make it legal in all states. You need to know your state laws. I cannot say this enough. Get state-specific training. There's things you can do in your state that other states are doing that you can't do. And if you don't have the training, you don't know that. So you're gonna try to do things in your state that you can't do, that are against the law. So get the training so you don't make these mistakes. So I know we talked about mistakes that notaries make, but if you get the proper training and learn what you're doing, you're really not going to have to worry about this. Now, everybody makes mistakes, but these are most of these that I was referring to are intentional mistakes. If you make a mistake and you know you made a mistake and you're able to go back and correct it, you're good to go. But as long as you're not out there trying to do anything that's against the law, or commit any type of fraud, you should be okay. And if you learn what you're doing, what you can do, what you can't do, you don't have to worry about this. Now, if any of this sounds like something you'd be interested in, make sure to hit that subscribe button and like this video for more insights on becoming a mobile notary. And if you have any questions or want to learn more, feel free to leave a comment or reach out. I'm here to help. Thanks for watching, and I hope this video has inspired you to consider this rewarding opportunity. I'll see you in the next video.